So I want to briefly take a look at the challenges of adopting LLMs in the legal sector from a sociological point of view, treating innovation as a socio-technical process, which means that excellence technically is not the only factor that determines which innovations actually find use and are widely adopted. And we want to understand what the non-technical factors are in the case of law and LLMs. And just to say that this work involves quite a few people within the project. The project itself is a socio-technical project. I particularly want to note the contributions of Josh Kelsall, I think, who is online today, Tom Sorrell, Serene Chi, Aisling, for example, who are all working to help to deliver a socio-technical understanding of innovation and adoption of law technologies, LLMs in law. So I want to begin with a brief history of evaluation techniques, benchmarks, metrics, and so forth. What we see here is the situation that academics are faced who are working in developing machine learning models. It's about getting onto that leaderboard, showing that your model is fractionally better, and it can just be fractional to move you up that leaderboard than other people's, and therefore that what you're doing is competitive, okay? Now, because the benchmarks and techniques have been serving that particular use, they have particular properties, and it has to be said that they've served the academic community very, very well. They've enabled the advance of machine learning techniques over the last 20, 30 years, to the point where now, of course, we're seeing them arguably reaching a level of performance that makes them suitable for application in the real world. The problem we are facing, however, is that the ways in which these machine learning models have been evaluated within academic circles does not necessarily render or yield results which are reliable when we think about using these machine learning models in real world situations and contexts. And that, of course, is the challenge that AdSolve is trying to address. So there is a growing awareness, I think, that techniques that have been honed for evaluating machine learning models in the context of academic work and advancing the field in some sense are not relevant, as I was saying, to understanding how they would perform in the real world. So, for example, the literature talks about real-world disconnect, okay? So differences in motivations and goals. The academic motivations and goals are not the same necessarily as someone who wants to deploy these models in the real world. An emphasis upon getting higher up the leaderboard does not necessarily match what someone who wants to choose between different machine learning models, not necessarily the way that they want to approach the way of deciding which one is going to be better. And so there's a need to have evaluation methods that can provide valid and reliable assessments for whether human needs are adequately satisfied, whether they match the ways in which these machine learning models, LLMs, for this project's purposes, are actually used, and the tasks that they're being used to support. And these tasks in the real world may turn out to be quite different from the rather narrowly defined tasks on which traditional benchmarking has relied on. And so we need to understand more about what those real world tasks are actually like, and then how we can incorporate the understanding of these real world tasks into the process of evaluating different machine learning models, different options that may be available to support that task. There's also a question about reliability. Now, academic research is competitive. And you will not be surprised to hear, I suppose, that given it's competitive, that sometimes people find it difficult to avoid the temptation of gaming the system a little bit, exploiting loopholes in the ways in which benchmarks, processes, metrics are defined in order to edge up further up that leaderboard. We might, if we're not particularly tolerant, we might call that cheating. I'll leave it up to you to judge. So there's a question of whether these traditional benchmarks, metrics, even in the academic context, can be totally relied upon. Examples of gaming have been discovered, and I think Jenny is going to be talking about examples of gaming that have arisen in the context of evaluating LLMs in legal use cases. Now, we've recently completed a rapid evidence review of the literature which has been studying the application of LLMs in law, which has involved the application against different kinds of tasks as defined by those who are doing the studies. We consulted 103 different research articles, I think from about the date of 2020, if I'm correct, maybe, well, around that date anyway. And once screened, 78 of these articles were included in the final review. A key theme that comes out of the analysis of the 78 articles is that a key aspect is performance of fine-tuned domain-specific models versus those more general-purpose models. Now, if you've had any kind of introduction to the application of LLMs in law, you will know that you can use ChatGPT to try and get an answer to some legal question you might have, and lay people have been doing that. These are not fine-tuned models, right? They're just trained on huge amounts of data. They're not specifically fine-tuned for law. Services are now becoming available through vendors such as Thomson Reuters, LexisNexis, of course, are fine-tuning them by introducing corpuses of legal documents. And so does the fine-tuning actually deliver benefits? That's one of the things that these studies have been looking at. And what they also report is that the primary metric is accuracy, is the results that comes out of using these machine learning models, these LLMs in law use cases. Are these results accurate? And the way that's measured has generally been through a quantitative metric, one of which is called ROUGE, which is recall-orientated understudy gisting evaluation, which is a bit of a tortured acronym, I have to say. But what that does is it compares the appearance of words in a reference document with the words that appear in a synthesized summary of those documents. And it does an automatic counting of how many times words appear across the source and the synthesized document. And therefore it can be done automatically, right? It's just a counting problem. The question is, and the criticism is, however, is that similarity measured by the presence, co-occurrence of words in two different documents, a source and a synthesized document, doesn't capture semantic accuracy. And therefore we need to move beyond that type of technique, which in academic circles has been quite robust and well used. And also, there's an absence we found in the engagement with legal professionals, people who are experts in doing legal practice, who surely have a lot to say about what tasks actually, how they would find, which are drawn from their own experience of practicing law, and therefore may be different from the more abstract definitions of tasks that we find in a lot of these studies. So we need more engagement with law professionals if we're going to be able to deliver better metrics for evaluating LLMs in legal practice. So, stakeholder-informed development of tasks. We need to move beyond abstract definitions of tasks, which are convenient for academics because it means it gives a sort of simple basis on which to then measure performance. Real-world tasks may be a lot more complicated. They may be embedded in a sequence of tasks, a workflow, and there may be interactions between the different parts of the workflow. We need to understand what those interactions are and how a task is situated in a bigger body of work that is used to deliver some final outcome. And so engaging with legal professionals is really key to understanding what tasks actually involve in the legal context. And we also need to take a lot of care about ethical considerations. Maria mentioned bias. There are a number of cases of systems. I think it's a Compass system, which was used to decide on parole board applications, which was found to be biased against ethnic minorities. Obviously, in legal practice, it would be a gross failure if there were that kind of biases leaking into the way in which legal use case LLMs are being deployed. And we need to think about privacy and security concerns so that data that's used to fine-tune models is not leaked to beyond the confines of the organization in which that data is held. So some recommendations have come out of this review. Good performance on a narrow legal task as defined by academics does not necessarily mean that suitable for a real-world legal use case. We need metrics that capture semantic accuracy in use, where there's complex legal decision-making being deployed, and legal reasoning is one of the examples that we'll be looking at in more detail later on, to see if there are ways in which we can effectively evaluate the quality of legal reasoning, where you have to take information from different sources and perhaps come to a conclusion about whether what the outcome of a legal case might be. Deductive reasoning. And we need to incorporate legal domain-specific evaluation methodologies with an emphasis on contextual quality and accuracy. And alignment with professional standards. That must surely be really essential in law practice. Every law practitioner is required to meet certain minimum standards of practice, and if that's not happening, then there can be consequences. So it's clear that tools must not maybe create risks for legal practitioners such that they may fall short of accepted standards. And if we're able to build some tools that will help to evaluate LLMs in legal practice, we need to think about the context in which they'll be deployed. Who will be using them? When will they be using them? Is it a one-off evaluation that enables choice between a service from one vendor compared with a service from another vendor? Or do we need to build evaluation into the work as a continuing process? That raises questions about governance, for example. Small law firms with fewer resources, less expertise to hand, perhaps certainly in the context of expertise in IT and natural language processing, their needs may be very different from large law firms. So how can we accommodate a range of different firms which have quite different resources available in order to assist them making decisions about which models would be most appropriate for them to use, which LLM service would be most appropriate. And we need to study what it means for tools and frameworks in the sense of having an understanding of the diversity of different tasks that go on within the legal practice, and how tools may be used at different stages, LLMs may be used at different stages, and how they are part of a workflow whose quality depends not just on the quality of individual steps, but is dependent upon what happens upstream and downstream of a particular step in that process. So I refer to this as socializing evaluation, taking a sociological approach to understanding what evaluation means for, in this case, law practitioners, and therefore how evaluation should be performed. What is the meaning of results that evaluation tools and frameworks might generate, and how may they be acted upon? What are the consequential actions of evaluating LLMs in this context? So we need robust matrix which do not generate results which are not congruent with expectations. We need alignment with professional legal standards. We need to involve stakeholders. Now, I've talked about involving law professionals, but we also need to involve a wider range of stakeholders, because in the end, the range of people who interact directly or indirectly with legal tech, with generative AI in law, actually will include members of the public. So we need to be able to deliver for them arguments that the tools that are being used are trustworthy, that they who are in receipt of legal advice from companies that use LLMs, that advice is trustworthy, and therefore they have confidence that these tools are being deployed in the right kind of ways, that they're being evaluated, that they actually perhaps may be subject to governance, so that we don't treat evaluation as being a one-off that happens when a particular tool is chosen for deployment by a law firm, but actually this can be revisited over time to make sure that the system continues to perform in a way which is congruent with legal professional needs. And beyond individual tasks, understanding the workflow, the ways in which individual tasks are linked together, and the relationship between them, and how that combination of tasks leads to the output which is then perhaps deployed in a particular case that will appear before a court. We need to understand not just the individual task, but the kind of wider shape and practice of law, so that if we introduce technologies into one part of it, supporting a particular task, we can be confident about, we understand also what effects that will have on tasks that appear downstream from that particular stage in the whole workflow. Okay, so for me that means trust architectures, which is not just about tools, it's also about competence, about training, and about having procedures in place that will enable that trust to be sustained over time. And when we have this goal, obviously, of delivering quality metrics which speak to the needs of the legal profession. Now, it's the case, however, that we can't be confident that what we think are the best quality metrics, the best quality tools, will necessarily find favor amongst the broader range of stakeholders within the legal domain, which includes, for example, vendors who want to sell services, legal services to law firms. They may have preferences for different metrics because those metrics may favor their products and services. And so what we're going to see is what I refer to as a social shaping of ways in which these products and services are evaluated, because stakeholders who have invested in producing legal services and products are powerful, and they may well be able to influence how standards are determined, which will shape how then the ways in which services and products will be evaluated and understood by potential users. So we need to be aware that evaluation is a marketing tool. And if it's a marketing tool, there'll be pressure for it to favor commercial interests. Evaluation is also expensive, and that may rule out efforts to promote evaluation methods which come from less well-resourced sources. So evaluation is going to be shaped by a range of different interests, and it's not always the case that the best quality will become the chosen standard in this or any other context that these systems are being deployed. So vendors are going to may be motivated to try and take control of the evaluation process, okay? And evaluation methods are performative in the sense that once adopted, then they're going to shape how evaluation methods evolve. Because they are accepted as standard, they're going to then be influential in what we take evaluation metrics to mean and how they should evolve over the future. And therefore, they're not passive objects. They actually influence the shape of future evaluation. So that concludes my talk. Just to say that, as Maria has been emphasizing, we want to engage with professionals in law. We need to know a lot more about law practice. We need to know a lot more about your needs if you're considering already adopting LLMs to support your work. We need to talk to law professionals in different roles, and also allied professionals who may be working in law or maybe, for example, working for companies that are developing LLMs for law practice. So I hope this event today will help to stimulate you and encourage you to work with us. We'd like to come and talk to you in greater depth over the next few months, so we can really feel confident that we understand what your needs are. Without that, we won't be able to deliver what this project promises. So I hope that will happen. Thank you.